Hello. We can have questions and interactive session from involving you. And so if someone can enable the screen sharing for me.
Sir, I'll be making you the host. I'll be making you the host for the time. Yes, sir.
So I have some slides that I will be sharing with you. 1 second, sorry. All right, are we, can we see the slides?
Yes, sir.
Good, great. So we're going to talk about just a general introduction to commercial arbitration. And so you have two different perspectives here. I'm going to have just a general overview. What is arbitration? We look at it generally as a private form of binding resolution. Some people refer to it as rent-a-judge. That the parties are able to, rather than going to the judicial system, they hire arbitrators. We as arbitrators sit as impartial members of a tribunal, but there's always some rules and regulations that bind the roles and procedure, process, and laws that we as arbitrators or members of the arbitration tribunal must follow. But as a general rule, the parties get to select who the arbitrators are, what rules apply, and what processes happen, perhaps even where and when those occurrences take place. And so our powers are fixed by the agreement of the parties and the rules that they choose to have us apply. And so we must make our awards comply with the laws that the parties have agreed to. Generally, they're quite specific. In some cases, not many, but in some cases, they can actually just empower us instead of abiding by a specific set of laws is just to impose a solution, a result, a judgment, an award that is perceived by us as arbitrators to be fair. And sometimes that's done for a specific reason because parties can't necessarily agree on the law that must be applied. Or they've set out the documents or procedures, the contractual terms that we must follow. And so why do we choose arbitration? Before I go on, VJ, do you have anything to say about just the scope or what is an arbitration itself before we talk about why parties choose arbitration?
Yeah, thanks, Tom, for this opportunity. And it is wonderful sharing the dais with you. You are such an accomplished arbitrator. And we have been connected through LinkedIn
long
time, and today I'm happy to meet you in this webinar. When the students approached, and it is a good initiative by them, they are making a headway towards intellectual debate and work in this area. And definitely it is a growing area. I must tell you, when I say about arbitration, this is one of the major practice area for lawyers and alike. In India, if I talk about arbitration, it is not a new thing. It was, in fact, we had a legislation in 1940, which used to cover the arbitration, which actually held the ground till 1996 when we adopted the ancestral model, and there was a requirement. And in fact, you would know in India, the liberalization happened in 1991, just like around the world. And when we started opening up of our markets, and there was a push of foreign direct investments, and many players started coming in, and business players started growing. So there was a essential need to have some mechanism, an alternate mechanism of dispute resolution, particularly the commercial disputes, because the court structure was not that adequate to deal with the commercial disputes for primarily, I can say, two reasons. One reason was pendency, because the courts were flooded with the normal public law matters that would include, criminal law cases, many of these cases which belong to the constitutional law, and they would not have much time to devote to the commercial matters, which actually required a lot of time to be dealt with. And in fact, what happens is when we have matters in courts, it is having too much of procedural requirements and formality. So business people don't like that particular formality. They wanted some amount of flexibility in the operation, so that when they are sitting for an arbitration, at least they can carry their cup of coffee with them. And so that kind of a flexibility is afforded by this mode of dispute resolution. But at the same time, they also have a wherewithal to get best of the minds to apply to their dispute and to get a resolution which is win-win for all, in a sense that they get, but the question was that what would be the enforceability of that particular award, whether this will be enforceable and considered as a court of decree. And that was the need because of which the arbitration and conciliation law got passed in 1996. And you can see that particular law holds ground. But I think I will devote some time on 2015 and 2019 amendments later on. But to talk about arbitration in a general sense, as you pointed out, I believe this is a wonderful mechanism of alternate dispute resolution and very well crafted legislation we have. At the same time, I believe this is a very important area of practice as well for young practitioners as well as old practitioners. And it is a growing market, I must tell you. India, as far as arbitration is concerned, the growth is huge.
Let's hear from the students on that, but let me talk about a couple other things. And when we get to the, I'll mention the 1996 Act in a bit, and then if you don't mind talking about the amendments, the 15 and 19 amendments, and then they'll get a better feel for it. But let's just talk about a couple things before we move on. This enforceability, this slide really talks about international commercial arbitration. The New York Convention is a mechanism for, in cross-border disputes, for the enforceability of an award across jurisdictions. And so domestic arbitration always has, in your country or my country or in many countries, we have our local laws that provide for the enforceability of an award. We call in arbitration, we call the judgment an award. In court, it's sometimes called an award. In different jurisdictions, it's called a judgment. But we refer to the result of what we do as arbitrators as an award. And there's very specific drafting requirements we as arbitrators are required to do to make sure that that award is enforceable. Not your country changes a little bit about the appealability of that award, but usually it's not appealable unless there's very specific reasons for it being found to be unfair. So we choose arbitration, or business people choose it for enforceability, for having some kind of neutrality in cross-border disputes. I don't want to be litigating my dispute in India against an Indian party. You don't want to be in the US because we think there's favoritism by the host country. So we choose a neutral forum. It could be London, Singapore, wherever it may be. There's Switzerland, there's lots of places that are perceived to be neutral sites for that. So we choose it for enforceability, neutrality. And then of course, Vijay already talks about flexibility, is that these rules, you can design the rules for us to follow. They're supposed to be less formal, especially now, Vijay, as you know, in the COVID area, we can have an arbitration like we're dressed now. We don't have to be as formal as we are in court. And we use tools like Zoom and other tools to create an opportunity to get parties a hearing while court systems are locked down or tribunals are locked down because of the COVID requirement. So we always thought that arbitration was going to be a more flexible way. The other thing I'd like to talk about is that in most cases, we can choose as parties, we can choose our arbitrators. And we may choose people who have certain experience. So if I have a dispute involving a pharma case, I may hire, and they're not always lawyers who are tribunal members, sometimes they're engineers. And so somebody may be involved in pharmaceutical engineering or the chemical engineering that involved in that, so that we have subject matter expertise. Here it's quite common if there's a dispute involving a project, a construction project, we'll have civil engineers on the panel, because in addition to lawyers or other kinds of experts, we find it very valuable to have engineers on the panel. And so we can gain some flexibility in choosing who we are. Customarily, Party A chooses an arbitrator, Party B chooses an arbitrator, and the two of them may select that third member of the panel to fill any gap in expertise that exists. And also we can be told we have to follow due process requirements, create some fairness, but the parties are able to give us some input on the rules and regulations that we're going to apply. One of the reasons we choose arbitration is, like I mentioned already, where there's different jurisdictions, or as mentioned already, where there's technical issues that need to be addressed by people who have expertise in those. One of the advantages of arbitration, is that we presume some kind of neutrality in international contracts. Also confidentiality. When you file a case, VJ, on behalf of someone against me, pretty much the whole world gets to see the court filings. I know in my country that there's public records. In arbitration, those filings are very confidential. And so a lot of people choose arbitration because there's a layer of confidentiality that keeps the public from knowing what our dispute is about. And so let's pause for a minute. And VJ, any thoughts about that before we talk about advantages and disadvantages, or any questions from the students? I think if I just redirect this shortly, VJ talked about that for students, this is a hot area. That this is, for career, learning about arbitration is really important. He talked about that already, and maybe it's time for the students to ask us some questions about how far we've gotten and how important it is to learn both domestic and international arbitrations for career purposes. But first, VJ, yeah.
Yes.
Any comment, VJ, before we take a question or two?
Yeah.
I'm going to stop the share. So
yeah. No, it is perfectly fine. And I think you touched upon two very important aspects, and the one is neutrality. So it is very important that neutrality has to be brought about. And what I feel is that if you see the Arbitration and Conciliation Act of the Indian legislation, you find that it has got basically three bifurcations in which it is arranged. And one deals with international commercial arbitration, and the other one is domestic arbitration. And now when we are talking about domestic arbitration through the court's interpretation, we find that if the outside parties have chosen India as a seat of arbitration, then the domestic arbitration rules governs that. And in all these particular dimensions, one thing which parties are looking for is neutrality. And you appropriately put that if one of the parties is in the host country where you are having the arbitration, there is some amount of bias comes in, or maybe perceived bias comes in, even if there is not perceived. And there is a famous saying of equity, the justice should not only be done, it should be seen to be done. Yeah. So right. That basically applies, and parties want a neutral forum where they can go and have a decision. This is one aspect. Another important aspect in arbitrability of disputes and thing is confidentiality, because these are business disputes, and the information which is shared is confidential, and it is very important that that particular data is kept confidential, and this cannot happen in public courts. Howsoever you can have mechanisms, there becomes a bit of a difficulty of ensuring that confidentiality. And unless the parties have that particular confidentiality clause with them, and they are sure that whatever they are submitting is going to remain confidential, they are not forthcoming to submit to that jurisdiction of arbitration. So it is very important that a mechanism of confidentiality, and you will find that the 2019 amendment as well as 2015, the present legislations which we are talking about, focuses upon confidentiality. It says that the confidentiality needs to be maintained. I have an experience of working with Competition Commission of India, and I recollect one of the major challenges which actually stopped Commission from bringing this combination regulation. I am talking about the merger regulation. So the merger regulation took time to be approved, and one of the contentious points was confidentiality. Because if you look at the competition legislation, that also talks about confidentiality. the industry didn't wanted this particular competition overview of the mergers and amalgamation on the point that what will happen to the data which we serve for examination to the commission, whether that will be confidential, because that is a highly confidential data. So confidentiality, I believe, goes to the core of the commercial enterprise, and because competition stands on information, either you can say information symmetry or information asymmetry.
Right.
So that information needs to be confidential. So this is what is my thought, and I believe it is pretty aligned as far as the arbitration as a mechanism is concerned.
Yeah.
One important point you raised about sectoral information and sectoral knowledge. And I believe in our country, in India, we have not been able to utilize this too much. In fact, if you will look at the arbitrators, this is who is ruling is basically the lawyers. So the people who are the lawyers, they are arbitrators. Class which is ruling is the retired judges.
Yeah.
So I believe this is what is happening as far as arbitration in India is concerned. I believe the day should come when we have designers arbitrators, we have healthcare arbitrators, we have construction people who are arbitrators. I think anyone, we have educators arbitrators. So anyone can be an arbitrator, because arbitration skill doesn't require much of a legal analysis and legal knowledge. It is basically, some basic principles which the arbitrator needs to follow, and that includes principles of natural justice. And I believe the things serve there. Thereafter, it is more of a technical understanding of the dispute, because if you are able to understand the commercial dispute, you will be able to resolve it. At that particular time, when I say this, I don't mean that the arbitrators who are lawyers and judges have not done well. In fact, if I must say, in India, they have done pretty well. And we have arbitrators, sought after arbitrators. I can name a few, like Justice V.K Singh is doing arbitration. Now he's a wonderful in economic understanding and everything. We have arbitrators like, I'm forgetting the name of justice, how I can forget that. He gave the AFCON's decision. And he's one of the, sought after arbitrators. Like this, we have plenty of arbitrators who are coming from judiciary. But at the same time, I believe it should be open, and people should not think that arbitration is only the cup of lawyers. And I believe the 2019 law has actually brought more clarity on this particular aspect.
When I first started doing work in India, VJ, there was some concern about the retired judges as arbitrators.
I'm sorry, Tom, sir, to interrupt you in between. I just wanted to ask you that, are you going to share the slides again?
Yeah, we'll go back to sharing the slides again.
Okay,
but I thought
can you admit few people because they're waiting in the waiting?
I'm doing it. Yeah, no, I've done that. Yeah.
Okay.
Yeah. No, they're all in now. I'm keeping an eye on it. Yeah.
Okay,
yeah.
Sure. Thank
I
you.
think everybody's in now. Yeah. It pops up on my screen. So what we were talking about is the perception of fairness, and in an international area, because of the primary use of a lot of retired judges, there weren't in India a lot of international cases. We're trying to change that now by not relying exclusively on retired judges. And I think the international perception was that when we do an international case, we generally a long period of time. Like we may fly somewhere for a week, 10 days, 2 weeks, and we do long days and repeated sessions. And that was not necessarily the practice of the Indian judges. So a team would fly in, they would have 1 day of hearing, and then they would be adjourned maybe for a month or two. And so the perception now is a bit better in trying to create international arbitration centers in India to compete, because India was losing a lot of business to Hong Kong, to Singapore, to London, of course, at the London court and the ICC in Paris. So India has done a lot in terms of trying to improve their perception of fairness and procedural due process in the big cases. One comment about confidentiality. and then we'll see if we have any questions.
V.K. sir, I have a question.
Sure.
That as Thomas sir mentioned that we are losing a lot of business, and as we see the composition of the new authority that has been set up under the 2019 Act, the composition of the board is mainly of the judges. So, sir, what kind of reform in this direction is needed in order to make India an arbitration hub?
This is what we're talking about. I'll defer to VJ because I think we have to make sure in this part we distinguish domestic versus international arbitration.
Yes.
My comments were about international arbitration, and because the domestic arbitration has always been handled locally, but your law firms, their ability to manage international arbitration locally would be enhanced and more business in country. I think there are thousands of cases in international arbitration over the years that got lost from being seated in India to seated in other countries. But Vijay, what are your thoughts about this?
Yeah, so I must tell you, see, what happened is I am a life member of this ICADR, which is actually being tasked for this international, Indian Council of Arbitration. So what is happening now is basically that particular body came under the Ministry of Law and Justice, and it was an autonomous body, however financed by Ministry of Law and Justice as a society. So that actually focuses on mediation and arbitration. So the challenge was, as you appropriately pointed out, that a lot of litigation, a lot of arbitration actually moved to Hong Kong and other places. And we in India were not able to provide that environment of dispute. And one of the major reasons behind it was that interference by courts. So if you see the legislation, there is a plenty of interference by courts at every stage. Either you talk about appointment of an arbitrator, you talk about deciding arbitrability, not giving a complete autonomy to competence principle. So these were the major challenges which were there. But I believe in 2019 amendment, they have tried to bring a council. So what they are trying to say is that there will be a body, and this particular body would recognize the institutional arbitration. So if you will see, one of the challenges which India used to face was a lack of institutional arbitration. So we didn't have plenty of institutional arbitrations which is promoted. I believe there is one Indian Council of Arbitration and ICADR. Yes. But again, if you will look at the constitution and their working philosophy, I believe it is not that open as it should be. So that was the one context with which it all started. But one point which 2019 amendment clearly focuses is that there is a need to establish institutional arbitration, and the law provides for that, though it is not yet notified. And if you will see, Arush, your question regarding whether it is focusing towards lawyers, though it starts, the first clause talks about lawyers under the Advocates Act, you have to also see the other clauses, which is quite generic in nature. So now it is completely upon the people who have arbitration skill. So if somebody is having a 15 years of experience in a particular field, and he undergoes arbitration training and is registered with one of these particular ad hoc institutions, he would be in a situation to do arbitration. I don't think there is any restriction on that in the present law which has been brought. However, to bring a culture just like Hong Kong and Singapore, it will take a bit of a time. And I believe the court's attitude, the attitude of the courts would deal with this more. It will depend completely as to how the courts are taking up the arbitration issues, whether they are relegating the issues to the arbitral tribunal for decision, or they are keeping it to themselves. So what happens is there is a kind of a feeling of keeping things to yourself. So that feeling has to go from courts. Once it goes away, then I believe the arbitration institutions will grow, because it cannot grow in the folds of the court structure. This is what is my understanding. Same is the situation with mediation, because I am a mediator as well, and I do trainings on mediation. And in fact, when I find mediation, why it is not successful, why it is not being done properly, one of the major reasons is that because court annexed mediation cannot work. You know, there is a need for institutional mediation. Similarly, institutional arbitration. Yeah. So my take is very clear. The law doesn't prohibit institutional arbitrations to grow. However, at the same time, interference of courts should reduce, and the things will move on, I believe.
This is exact 100% agree with everything you just said, BJ. The problem was, if I'm a practitioner in the U.S., I know the Indian courts were very prone, pre the 2019 law, very prone to interfere with the case. And so I might be choosing a tribunal, but I never knew to what extent the Indian courts were going to interfere with the tribunal's decision. In other countries, the tribunal gets to decide 99% of what happens, and we don't worry about interference. Yeah. The 2019 law is designed to try to do that, but you're right, BJ. It's a mindset. It's hard to tell a judge you don't have the authority to do something, because as a judge, we feel we have a lot of authority. And so it's a mindset change, and I think that takes time and some judicial decisions that say, no, you're not allowed to do that. And so it may take a little bit more time for there to be a body of law that lets the judiciary know the boundaries under which they operate under the 2019 law.
Right.
Actually, Tom, I must tell you, this mindset is changing as far as India is concerned, and this can be witnessed from the ease of doing business ranking of the country.
Right.
Yeah.
So you see there is a significant improvement as far as ease of doing business ranking is concerned.
Yeah.
And the other day we were hearing the Joint Secretary, Ministry of Law and Justice, in one of our programs, and he was addressing us on the parameter in ease of doing business rankings, that is enforcing contracts, where we still have to do a lot. And I believe the reforms are targeted towards that now. So the focus is there. Yeah. So more of a focus towards having, less time. So timelines are now earmarked in legislations that courts have to decide the disputes in particular timeline. So if you will see the present Companies Act as well, we have got a new tribunal which deals with the company legislation and company disputes, that is National Company Law Tribunal. And under the law, they are bound to dispose of the dispute under a particular period. So it is under the law. Though they can extend it, that is a different matter. But for the first time, the law prescribes a time period within which they have to dispose of the dispute. I believe it is a welcome step, and it is changing the mindset, because now people have to dispose of the dispute. Same is the situation with insolvency and bankruptcy court. So if you will see the modern legislation, I believe in the last 5 years, I believe there is a huge focus on prescribing timelines for tribunals to come up with the dispute resolution within a particular time. And I believe this is a welcome step, and that will change this mindset of lingering on with the disputes for a longer period of time. So yeah,
because we both share an interest in mediation as well, didn't the Companies Act have some provisions about mediating disputes as well?
Yes. So unfortunately, it had a provision of having a panel. So what the law says, basically section 442 of the Companies Act, that the central government will constitute a mediation and conciliation panel. That is section 442 of the Companies Act. So in fact, there were panels constituted across, and this is the responsibility of the regional directors of the company affairs. They did that. However, the tribunals have not, the NCLT has not referred any dispute to the mediation. So far we have not seen any success around there, but I believe the provision is there over a period, maybe because if you will see the Commercial Courts Act, there is a compulsory pre-mediation introduced there. So if that is the situation, then I believe this will come up.
Let's see if there's any other, are there any other questions from the participants before?
Sir, I have one question directed to you. Supposedly, if you agree to have your dispute decided through binding arbitration, so do you give up the right to a jury trial?
Yeah, no, usually what happens is arbitration, and I have a few slides in a minute to talk about how do you get to an arbitration, but it's either imposed upon you by some industry that you belong to or a contract term, or you can have a dispute and decide after the dispute arises to do a submission
1.5 months
and put that to it. So you have agreed with the other party in your contract to arbitration and a binding nature.
Right.
Does that answer your question?
Right, sir.
Yeah. All right. There's a question from Teresa, I think. Someone was saying they had a question.
Sir, I believe that was just a layover of voice. Sir, I have a question to V.K. sir. Sir, the 1996 Act, the section 21F defines international commercial arbitration, and the phrase considered as commercial under the law is mentioned there. Sir, what is the meaning of the term commercial here?
Arush, I think the Supreme Court has dealt with this particular issue as to what do you mean by commercial, and it was RM Investment Trading versus Boeing case. And they basically say that it is a broad interpretation you have to give to the term commercial. So it exactly says it should be broadly having the manifold activities which an integral part of the international trade today. So there is no straitjacket formula to define this commercial. But I believe commercial gets defined by way of the activities which is being conducted by the businesses, and I believe it is subject to case basis, I believe, because when you are looking at the international commercial dispute, you also look at the commercial transaction, what exactly it is, right? So, and that is where I believe arbitrability also gets decided, basically, because unless it is a commercial dispute, this is one first point of examination, basically. You first see whether it is a commercial dispute or not. And if it has got elements like, say, for example, complex fraud, so that doesn't amount to a commercial dispute for the the definition under the Arbitration and Conciliation Act. So I believe the definition is quite broad, relatable to commercial, and then it is interpreted like that. But Supreme Court has said that it is a broader definition.
Okay, Vijay sir, we have a question from the audience that directed to you. From Ananya Jadhav. She's saying, good evening.
I think you guys could have asked me questions later. You asked more questions to Tom. Tom is the...
Oh, it's good. No, I'm because I'll comment too. Go ahead. Yeah.
Sure.
No, I was just... yeah, please go ahead, Rishabh.
Yes, sir. So Ananya Jadhav has a question. She says, good evening. Can Vijay sir also provide information as how a law graduate can start practicing arbitration both locally and internationally?
No, come again.
She's just asking you that how a law graduate can start practicing arbitration both locally and internationally. I believe both of you, even Vijay sir, you and even Tom, so both of you can give your views upon it.
See, I'll tell you, it is quite an interesting question, and I have seen young lawyers practicing, and in fact, one of my known practitioner, quite young practitioner, I believe 3 to 4 years of practice in India, has formed an organization called Arbin Sol, and is located in US, and he's doing arbitration from there in India, and it is about, and he has done a LLM in dispute resolution. So they focused specifically on arbitration. They did a master's there. I believe anyone can pursue this. They have to have a focus and focus towards dispute resolution. So I don't think that, there is only one straight trajectory for moving into arbitration. All experiences, because I believe if you want to become an arbitrator, you need to understand how courts operate. Right. Because if you want to join a firm, one of the major works would be to liaison, in the, like for example, appointment of an arbitrator, maybe you want some basic orders. So I believe initial days, some training of all forms of dispute and litigation is very much important. So, and along with that, nowadays, I believe all the firms and all, in fact, the senior lawyers are having arbitration practice. I recollect when I did my internship, when I started my career, I was doing, litigation along with one of the senior advocates in Nagpur. He used to have arbitration practice, and I used to accompany to him to a hotel. And it was quite a pleasant, that is what I was referring to, it was quite a wonderful experience for me, because in the morning in the courts with such of a gown and everything, and in the evening in the arbitration, and you go to the hotel and such a nice ambience with all AC and chair, and you sit there and hear the disputes, and thereafter, there is a dinner also served. You feel good about it.
Yeah.
So I believe it is your choice, and accordingly you can frame your, what my perspective for you people would be as students particularly, chart out your career growth as to what you want. Fix yourself some years that yes, I will spend this much of year in courts, this much of year into this practice, and then move ahead with arbitration. Maybe I will get an advanced degree in arbitration and then register myself as an arbitrator somewhere and move ahead like that. Training is must. So this is what is the way ahead. I believe nothing, not a secret recipe anymore. Anyone can do this, right?
Yeah.
Right.
It's only about getting yourself motivated and moving in a goal-directed fashion.
And if I can add, and having a plan. So I think there's a few different methods to do there. The internship in all of the big firms in India are doing arbitration. So you can find out who they are, who they are already. The route to an LLM, I know for quite a while, there's very good LLM programs in the UK at King's College, Queen Mary, in the London School of Economics. They have really dedicated dispute resolution or even specialized international arbitration LLMs. But, I don't give advice about that because there's a cost to all of that.
Right.
And education in other countries, I'm embarrassed by the cost of education in my country, whether it has value or they don't. I don't want to get into that, but it depends upon your family, your situation, and all of that. The other route that we don't often talk about is internships at the tribunal. So LCIA, everybody has the opportunity for young graduates to be an intern in the tribunal itself, in Paris, in London, and you gain a lot of knowledge, but also network. So you're helping manage the administering cases, so you get to know the firms, the lawyers, and it increases knowledge and networking. And Singapore, Hong Kong all have these internship opportunities, which I encourage all of you to start looking at now. You just get online and look at their internship opportunities. That's another entryway into it. That is, I'm not saying it's a lucrative position or anything like that, but it creates an opportunity depending upon your time and your budget and all of that. We have programs in the US too, LLM programs that are opportunities to learn and then even stay practicing here for a while with the firm and then take that knowledge back to India or whatever country you want to be in. But having a plan early and thinking about that, I know a student who I met one of the first times I came to India who had such a plan. He graduated, he worked for a short time, and then accumulated enough money to go for a one-year LLM at Queen Mary in international dispute resolution. And then he's back, I think he's still at Khaitan & Co. now in Delhi, and is now moving up the ranks as an international arbitration practitioner for them. But he had a plan. He saved enough money to do 1 year. He lived a very Spartan life for that 1 year, but it worked for him. And now he's a recognized practitioner in India now. So think about a plan, be disciplined about it. And of course, as VJ will tell you, becoming an expert. You have to study, you have to become a master in some way, and be willing to learn from the seniors that you work with.
Right, sir. So one more question directed to you, Tom, sir. So this question has been asked by Bhavya Gupta. So he's asking, is there a jurisdiction of arbitral tribunal?
We have the jurisdiction that the parties give us. And
Okay.
so they empower us and BJ mentioned the difference between ad hoc and tribunals. And so that's, let's just cover that. Ad hoc means that the parties don't go to an institution like the ICC or the HKIAC, any arbitration center, but just hire maybe people independently to do that. And they would impose in their arbitration agreement what rules we follow. We don't have to be working for an ICC case for someone to say the rules you'll follow are the ICC rules of arbitration or the HKIAC rules of arbitration. So we get our jurisdiction from the parties. The problem was, as Vijay mentioned before, is once you give us the jurisdiction, it doesn't stop you from trying to challenge what we're doing in the courts in India or in some other country. And that's the challenge. And I can point out that not necessarily you guys as young lawyers enjoy that, because you can be earning fees in the tribunal and then you can decide to file a lawsuit in court. And so giving the arbitral tribunal all the jurisdiction may limit your fees in some way, because you're not going to be able to have parallel cases going in court and all that. But usually in many countries, this doctrine of competence that Vijay talked about is we have the authority to decide the arbitrability of the dispute and whether or not what rules, process, and procedures we employ. We can decide what documents we're going to look at, how long witnesses are given to testify, how much cross-examination, if any, is allowed by witnesses. We have a lot of authority. And so that process is basically turned over to the tribunal. Vijay, comment, please. Yeah.
Yes, you have appropriately covered, Tom. I think this is what is the process as far as jurisdiction of arbitral tribunal is concerned. And one thing which one should note as far as Indian jurisdiction is concerned, that courts are getting quite conscious about their role in arbitration, and they are withdrawing. It is no more a situation as used to be maybe 10 years before or 5 years before, because the legislation is setting it right, as well as the mindset is changing, I believe. Because if you will look at the latest cases as far as arbitrability of disputes is also concerned, and particularly if I may refer to two sections, one section 9 and I think the section 17, it talks about interim relief of to be given by the arbitral tribunal. And whenever somebody approaches, for an interim relief to the court at the first instance, the court would not generally give the interim relief under section 9, and it would direct the parties to wait for the time period by the arbitral tribunal to give the interim relief. Because previously, if you will see, a lot of time used to be spent in appointment of arbitrator itself, 12 to 18 months for appointment of arbitrator and fixing as to whether the jurisdiction of arbitration tribunal will be there or not. This period is now reduced to 60 days, I believe. And the interim relief, they say that unless it is very, very pertinent and which cannot be granted in section 17, the interim relief generally is not allowed at that particular stage. So I believe there is a change which is happening now, and more powers to the arbitral tribunal is being granted. Point is that now we are talking about institutional arbitration, and I believe India is preparing itself for that, though it is not yet notified, but I am sure the things are moving in right direction, and shortly you will have that institutional arbitration mechanism in place. And once it is coming, then you will also have accreditation of arbitrators, you will have ranking of arbitrators. There will be plenty of things which will actually develop the arbitration ecosystem in the country, which I believe is very, very important at present. It would not be just be governed by the ad hoc system. It will have some mechanism in place, which I believe is a need of the hour. Yeah. So I hope I answered the question.
these things develop over time because, for example, even now we're seeing a need for emergency arbitrations where these long time lapses that occurred even in the appointment process can be circumvented if you go to a tribunal, and there are some of us who agree to hear matters on an emergency basis where we're available, because in some cases there are issues that can't wait 60, 90, 180 or even a year for decision. And so as the competency of the jurisdiction improves, the systems are creating tribunals to meet the needs of the parties. And as that happens, the bar itself becomes more prone to keep cases in countries where there is the ability to adapt to the needs of the parties. And so it's going to be interesting to see how India responds to all of these the institutional methods that are in place in other countries and comes up to speed, because you guys have a lot of work. I mean, India has a huge economy. They do business cross-border around the world, and there's a huge amount of arbitration that's available and is currently being used. And if you can create an ecosystem, like VJ says, within the country, the young lawyers are in a good position, aren't they? The law students now, in terms of international dispute resolution, they can find a niche, and it's a fun practice, right? I mean, you're dealing with interesting cases, sometimes cutting edge. You look at now with this COVID thing is crazy, but if you look at what could happen with regard to the development of vaccines and cross-border sales and markets for who's buying vaccines and all the other parts that go towards a vaccine, the injection devices, there are going to be huge contracts let, and I'm sure India is going to be some of the contracting parties for that. And every time there is a big money case, there's big money disputes. Right? So there's going to be disputes about how we get vaccines, who's supplying what parts, are they defective, are they good? So it's really a great opportunity for countries who can produce all the parts that go into things that we're administering for this COVID crisis now. Yeah. I wish I was I wish I was starting over. You know, we talked
younger enough, Tom.
Yeah, we talked about the cost, or maybe we didn't, but let's talk briefly about one of the advantages of arbitration was always thought to be it could keep the cost down.
Right.
But keep in mind, everybody, that when you place a matter in arbitration, you're paying the judges too. In the court system, you're not. And so you're paying the 3 arbitrators, sometimes 1, but usually 3, you're paying their fees as well as the legal fees. And over the years, those fees increased dramatically. So in my slides, we'll skip the slides for a moment, but I've talked about the advantages of arbitration is cost and the disadvantages of arbitration is cost, because over time, we've seen those costs accelerate. And now the parties, meaning the companies that are in arbitration, are seeing that what we thought was going to be faster and less costly is now becoming slower and more costly. And it's our job as arbitration tribunal members or institutions to try to help manage that. And so we got to keep aware of cost and time. We can't let a case go on for 5, 6, 7 years. I think, VJ, in India, we saw another problem that we haven't talked about yet is the time lag between the final hearing date and the presentation of the award. And the 2016 Act was trying to help resolve that time lag. I'll let you talk about that because that's part of what we're talking about for India. Yeah.
Right. So actually, this is a legacy which gets carried from the court system, because in courts also many a times orders are reserved and then kept for long till it is pronounced. So that is what was the practice which was going on. But I believe now the things have improved.
Yeah.
And particularly after the legislation which has come, particularly if you look at the 2019, it specifically gives a spick and span time of 12 months, extendable by another 6 months. So I believe the things are pretty clear. And so now I believe the arbitrator who is sitting for an arbitration simultaneously starts writing an order. So it is no more a situation that he keeps on the notes and then later on he drafts the order. Because these are big disputes, and you can imagine if somebody who is not writing the order while he is doing the hearing, again he has to revisit the whole case to write the order, because that will be a quite detailed order with all details there. Because this award is not the last thing which happens, because if you will see the statistics, you will find that majority of these particular orders are challenged under Section 34. So, so actually these orders have to be of that particular quality which gets challenged actually before the court. Not only this, if you will see the 2019 law, it talks about a very interesting thing that is called fundamentals policy of Indian law. So an order can be challenged under this particular ground of opposing the fundamental policy of Indian law. I'm talking about international commercial arbitration. So if these particular orders are not sufficiently detailed, they may be, considered as if non-application of mind by the arbitrator. So I believe there is a pros and cons of this particular thing, but definitely the law now is clear that the order has to be given as fast as possible, but not later than 12 months, extendable to another 6 months. So this is one point. Another important point which has come up is about the proceedings. So this time period has to be calculated, once the proceedings between two parties are completed. That is, I'm talking about the exchange of the written submissions and their discussion. So that needs to complete as soon as possible. I believe 6 months. That is what is the period which is mentioned.
This ties in nicely, to a question in the chat. What are the pros and cons of being an arbitrator?
Yes, that is what I
So
was
one of the pros is it can be exciting. In the old days, we could fly to this country, that country, or whatever. There's sometimes interesting cases. One of the cons is this what VJ just talked about. You have to be meticulous, right? You in cases that are complicated, you have to be, you can't doze off. You know what I mean? Is you have to be on your best game all the time, because the cases are complicated. The lawyering is often quite excellent, and they're very sharp lawyers, and you can be embarrassed, because one of the risks of being a con is that you miss something, and you write an award and you've totally missed something, and they institute some legal proceeding, and it's pointed out to the world that this arbitrator completely blew it, right? And so one of the cons is you can be embarrassed. And also is that there's some stress, right? Because you are often called upon to make important decisions, and sometimes there are cases that affect more than just the parties before you. For example, let's use the COVID thing, pharma. There are big publicly traded companies whose stock value goes up or down based upon the award that we might enter as a tribunal, which gives me one chance, and then we'll move on to the next question, to talk about confidentiality again. And so we talked about confidentiality of the process, but when I'm an arbitrator on a case that is involved a publicly traded company, I have to be very cautious about the documents that have been submitted to me, or even my draft award. If somebody knows I'm an arbitrator on a case involving Pfizer or Glaxo or something like that, and they may hack me, right? Because they want to see what my notes say, what my draft award might say, because they're going to buy or sell that stock according to that. So there's a lot of stress with cybersecurity issues and all that as well now. Let's see what other questions there are. I think there's a couple more in the chat. What do you think of arbitration cases end up going to court nonetheless? We've talked about that. I think, VJ, already you did a pretty good job of covering that. What can be done if one party ignores the arbitration agreement and commences court proceedings? We'll each talk about that. I'll go first, VJ. Here we would file a some kind of petition in the court, response to that petition saying, here's the arbitration agreement, and the court has no jurisdiction. And depending on how courts look at that, they're going to say, yes, the arbitration tribunal should hear that. Other countries may look at it differently, but VJ, what's your thought about that?
I think it is a pretty simple procedure here. Once an arbitration proceeding commences, I don't think that the courts are going to entertain that particular matter unless the arbitration proceeding gets stopped or terminated. So if you will see the Arbitration Conciliation Act, there is a section which deals with termination of the proceedings. So if it is terminated as per the Arbitration Conciliation Act, then definitely court will entertain. Otherwise, you need to get your proceedings terminated. So say, for example, A and B are into arbitration proceedings. Like, for example, say A institutes an arbitration proceedings. Arbitration can proceed only when the second party agrees to it. It cannot be an ex-party arbitration. So that particular situation gets resolved at that stage itself before somebody proceeds with that particular aspect. So if there is an arbitration agreement and one of the parties is not agreeing to the arbitration agreement, that means he is objecting to the arbitration agreement. That calls for the proceeding wherein the arbitrator basically, ideally, he will decide as to whether there is an arbitration agreement or not, unless it is patently illegal. So there is a point of patent illegality also. And for domestic arbitration that applies. So if it is a patently illegal clause or something, so that will form a different matter of adjudication before the courts. So I don't think a legitimately entered agreement which has got an arbitration clause can be just hushed away like that.
I'm conscious of time, so Arush, you tell us how. I think we're at the hour, but I'm happy to stay on. But we have lots of other topics to cover, but I think the questions are
may continue if you and Vijay sir can provide us with your time.
So Parth, I think we should take questions and then close it. So because I think we have already taken so many points. In fact, we have covered the whole paraphernalia of arbitration mechanism.
Right.
So if audience have any specific question, we will be happy to answer that. Otherwise, we will call it a day.
Oh, sounds good to
me. For me, it is an evening, and for Tom, it is a morning. Probably he will go for breakfast. I will go for dinner.
Sure. So anyone who wants to ask a question can write that up in the chat, and we will convey it to the panelists.
While we're waiting for that, there's a new organization that's about to launch. VJ, you may know about it. APCAM, the Asia Pacific Arbitration and Mediation Center. I think this week coming up, they're launching, and it's. I have one slide that lists all the different countries.
In fact, in India, there are many institutional arbitrations have already come up. Like, for example, Bombay Chamber of Commerce have their own. There is a Mumbai International Arbitration Center, MIAC, that has come very well and it has got a backing of state government of Maharashtra. If you look at in Delhi, we are talking about ICADR, Indian Council of Arbitration used to be there. So I believe now there is a momentum as far as India is concerned. There will be plenty of institutions which will be coming up as far as arbitration, institutional arbitration is concerned.
Sir, I have a question directed for you both, if I may. So the question is, are there procedural safeguards to assure that an arbitrator selected through the list method has no conflicts of interest, per se?
I think the 2019 amendment, Rishabh, addresses this particular issue. In fact, if you will look at it, I think Schedule 5 of the amended regulation, amended law, it specifically prescribes 34 clauses of conflict of interest as to how the conflict of interest can happen. So I believe that sufficiently gives a clarity as far as conflict of interest of arbitrator is concerned. And arbitrator has to declare that he or she doesn't have that conflict of interest. So they are professionally bound to disclose that before taking the assignment. So I believe that will be taken care of. Yeah. I don't think there would be any conflict of interest remaining. And if it remains, then obviously parties are there to challenge it. So I believe the system works like that. You know, this whole system of dispute resolution works on the parameter of two parties. One party is interested, and that is why we say this is, you know, in personam discussion. So parties are vigilant about their rights, so they make sure that the procedure is followed.
This is a very interesting area because we all have obligations to disclose. It's quite hard to disclose everything. But what we see in some jurisdictions is that a party may have a possible conflict of interest or know of one on my part. I'll give you an example. And not declare that, but wait until after the award. And if the award is against your interest, then you do it. So for example, Arush, we're a few years down the line, and you're working at a firm, and I'm an arbitrator on a case, and you know that Kumar asked me to participate in this session. I don't declare that because I've already forgotten about Kumar. You know, it's history. I enter an award in favor. He's working at one firm, you're at the other firm, and then you decide to say Valenti didn't disclose that Kumar, and he had emailed, he invited you to speak, you spoke at this thing, it was an hour long, you know him by first name, he calls you Tom, blah, blah, blah. And that could look bad to me, right? And so what I do on my disclosure form is say something as simple as, I attend a lot of conferences, I do a lot of online sessions, I don't keep track of everybody attending. I make a blanket disclosure like that to make sure I don't embarrass myself. Remember I said about one of the cons is that you can be embarrassed. And so it's really hard because it's very easy for people to say you did something wrong. Especially like for VJ or I who do lots of things online or do talks. You know, I may have sat at a conference at the same table as somebody who now is with a firm that I'm arbitrating a case on. I may not remember it. Do you keep track of everybody sitting at a table of 10 at a conference? No. So the conflict of interest thing is quite challenging for us to manage. There are some software programs that help us keep track of the cases we're on, but not necessarily who attends what conferences. And so it's a good question, but it's a strategy for law firms to use to set aside an award that goes against them.
Mr. Valenti,
but again, I believe this particular strategy doesn't work, Tom. I think courts are now conscious about it. And in fact, now you can see there are decisions in which Supreme Court has differentiated between a fraud simpliciter and complex fraud.
Yes.
So in case of fraud simpliciter, they are no more entertaining that particular matter, saying that that actually excludes the arbitration, because they are conscious that there may be situations wherein parties are just bringing up these particular issues to scuttle the arbitration agreement. So this is one part of it. If I may take this particular question by Bhavya Gupta, she is asking about this defaults or disobeys the order of arbitrator. I think this particular matter is pretty settled now. In fact, in one of the decisions, if I may quote Alka Chandravar versus Samshul Ishwar, Bombay High Court said that contempt proceedings cannot be launched by the arbitrator and arbitral tribunal. They cannot recommend for that. However, Supreme Court actually has said that then there is no point of providing interim relief under Section 17 of the Arbitration Act. So if you don't give teeth to the arbitral tribunal, and people are not following the order of the arbitral tribunal, then there is no fun in having this mechanism. And they have actually, Supreme Court has ruled and said that yes, Now, the parties, the arbitral tribunal would have would have a right actually to go ahead with recommending for contempt of courts proceedings. So that way, I believe this is ensured that parties don't default or disobey the orders of the arbitral tribunal, particularly in relation to the interim relief. And after the award, it is execution, and then there is a court proceedings which happens. So I believe that it gets taken care of by that.
Sir, I believe that all questions are answered, and we now move on to the concluding remarks.
Yes,
First by Thomas sir, and then followed by V.K sir for a period of 60 seconds, if you may.
Okay, thank you. I appreciate the invitation to be with all of you. I just put my email address in the chat box, so if anybody has any other question or concern or just want my thoughts about anything, feel free to contact me by email. I'm happy to do that. I particularly enjoyed this session because I think VJ and I, hopefully we answered all the questions. We gave you some thoughts about the topic, very interesting topic about career options for you. I'm always happy to be invited back, and I thank the organizers. You have a wonderful thing going on here with these seminars, webinars, whatever you want to call it, taking advantage of your thirst for knowledge, and maybe a few of us who know a few things that we can share with you. So I appreciate the opportunity and look forward to the next one.
Thank you so much, sir. It's an honor to have you on board. Vijay sir, please.
Yeah, thank you, Rishabh and Arush. Thank you for inviting me. And I was particularly excited when I saw the name of Tom here in this particular session. And it was wonderful connecting. And it gave an opportunity to actually you all know I work in the area of business law and corporate law.
Right.
And generally, that is what is my area. I am not into arbitration, but this session gave me an opportunity to actually revisit a lot of things, and that is what I did. And it was a wonderful learning experience for me as well, particularly the questions which came. So that were quite invigorating questions and very wonderful. Thanks, Tom, for the Chicago memories, and I believe I went back in time there, and particularly your lake, which is very, very beautiful there. So
no, it's closed. COVID. They don't. Yeah. The lake is closed. They won't let anybody on the beaches for the COVID.
Okay.
We have a nice lake, but we can only see it. We can't be at it anymore.
Okay, so but it is wonderful. I recollect when we went, we actually swam in that particular lake. So it was interesting discussion, and I think this kind of discussions allows an opportunity to young scholars and practitioners or aspirants of arbitration, and let us see, this ADR should move on, because I believe that is the future.
Right, sir. And thank you so much, sir, for accepting both of you for accepting our request. As even Professor Singh is our dean, and we are very glad to have him as our professor and a student. And thank you so much, Tom, sir, for joining us. It's great, and we are hoping to.
Before concluding, just a reminder and announcement that this is our third webinar series. The first was investor-state arbitration, where we check the validity of the TikTok ban that India has done. The second was the force majeure material adverse change, the session. And the third is what after law, that is going to be held on the 8th. So there we analyze the various options that students have after doing law. So sir, it was great to have you on board. And we wish that we can continue this collaboration with all the professionals, including the esteemed panelists today.
Thank you so much, sir. We look to have a session again in the future.
Thank you, Arush and Rishabh. Keep it up. Good work. Thank you. Bye-bye.
Bye, sir.
Thank you, Tom.
Bye.
Bye, sir.